Hello friends, in the series on the income tax cases, today we will discuss an issue regarding the filing of Form 67. In the present case, there were three very important issues which were before the SMC bench of Pune ITAT. First issue was that whether it is necessary to mention in the double taxation avoidance agreement that Form 67 is to be filed. The second was that whether the filing of Form 67 is directory. And the third issue was that whether the timings of filing Form 67s are mandatory or directory. All these issues have been taken by the Honorable ITAT Pune SMC bench in the case of Akshay, Rangroji, Umale versus Deputy Commissioner of Income Tax. And this case has been reported in 110 ITR, short notes 5. The date of the judgment is 1st February 2024. In the present case, the assessee was having some income in the foreign country. The assessee paid the tax on that income in that foreign country, and when the assessee filed the return in India, his tax liability was also coming on the foreign income, but he was entitled to claim according to section 90 the foreign tax credit on that income, but the assessee was not able to file the return under section 139 subsection 1, that is the original return, but the assessee filed the return under section 139 subsection 4, that is the belated return. So obviously the assessee filed its Form 67 at the time of filing the return, that is the belated return under section 139 subsection 4. The CPC disallowed the foreign tax credit on the sole ground that the foreign tax credit cannot be allowed to the assessee simply because of the reason that the assessee has not filed this form under the timeliness of the original return, that is section 139 subsection 1. The assessee moved to the CIT appeal. The CIT appeal disallowed the appeal of the assessee. Disallowing the appeals by the CIT appeals on these issues also gave a message that nowadays the CIT appeal, either they are not taking the pain to read the submissions of the assessee, or they do not have the guts to pass the order according to the law. They are just acting as a second assessing officer and just cementing the assessment orders of the assessing officers. When this matter came before the tribunal, the assessee was raising an out of the box ground also. The assessee was saying that when there is double taxation avoidance agreement and the provisions of the act, and when there is a conflict, then the double taxation avoidance agreement prevails. On this point, the tribunal gave a line of distinction between the applicability of the double taxation avoidance agreement and the provisions of the act. The tribunal said that when there is a difference of rate as per the double taxation avoidance agreement and as per the act, then the rates which are lower in the double taxation avoidance agreement prevails. There is no doubt about that. But it does not give a general rule that double taxation avoidance agreement rule over the act and the rules in general, meaning thereby that if there is no specific provision in the double taxation avoidance agreement, basic rule will prevail as per the Income Tax Act. The tribunal said that rules are subordinate pieces of legislation to facilitate the carrying out of the objective of the main legislation. The tribunal said that if we read section 90, 90A, 91, Rule 128 and the double taxation avoidance agreement in conjunction, then a very clear law comes out that the filing of Form 67 is mandatory, but the timing of Form 67 is directory, meaning thereby that if the assessee files Form 67 up to the date of the processing of the return or either up to the date of completion of the assessment order, then it will be a sufficient compliance of law according to Rule 128 and Section 90 and according to double taxation avoidance agreement. So in the present case, the appeal of the assessee was not entertained on the technical ground, but on this ground that the timing of Form 67 is directory. So the assessee was gave relief by the tribunal on the ground that if the Form 67 is filed even up to the date of the assessment, then the filing of Form 67 will be allowed and consequently the foreign tax credit will be allowed. At the end of this video, once again I am repeating the name of the case. The name of the case is Akshay, Rangroji, Umale versus Deputy Commissioner of Income Tax, and this case has been reported in 110 ITR short notes 5, and the date of the judgment is 1st February 2024. Thank you, friends.